All right, we're going to go quickly through all the questions labeled with B, J, C, or P, which means bureaucracy, judiciary, civil rights, or civil liberties. We won't have gotten to the civil rights in class, but I'll go ahead and give you the answers for when next week we do get to them. And then P, actually P's not for presidency, it's for policy questions. And remember, the B does not mean that the answer is B. It means that this one's about the bureaucracy. Now, I think this is for me, was the most challenging one on the test. I think in previous videos I said it was 6. It's actually it's number 5. Because it's about an obscure fact, a way of naming bureaucratic agencies. But let's see if we can take an educated guess and get the answer. The National Aeronautics and Space Administration, so NASA is an example of, do they regulate people's private actions and make rules for them? Whether it's people or businesses? No. So I don't think they're regulatory. All right. An independent agency, maybe, I guess, maybe they somehow are independent. They don't seem to be a government corporation. All right. At least I don't think they are. There are things that are government corporations that are sort of semi-public, or run like a corporation, they're set up like a corporation, or they have corporation in the name. But that's not my guess. A government department, no. Remember, the departments are like the Department of the Interior and the Department of State and the Department of Defense. Those are pretty big divisions of the bureaucracy led by the cabinet secretaries. And that's certainly not, NASA's not a whole one of those. And I don't know what a federal board is, but I don't think it's one of those. I would have guessed B, independent agency. I think that's the answer. But something to keep in mind is you're very unlikely to get all 60 of them right. So don't expect to know immediately the answer to every question. All right? You may not know it. You should guess. There is no penalty for guessing. There used to be, there's not anymore. You should always guess. They assume you're going to guess. If you don't know, then you should not be intimidated just because you don't know every answer to every question. You should just try to get more than half's a good rule of thumb, but you should try to get more than half. You should try to get them all right, and then hopefully you'll get more than half. All right.
On the test, are you penalized for wrong answer?
No, once again, you're not penalized for... You used to be on the SAT and on this penalized for wrong answer. On the AP test, you're no longer missing a question and leaving it blank are exactly the same. So you don't want to leave blank. You want to just see if you can happen to guess right. All right? And they're building that into the way they score it, assuming you're going to guess right on a few of them. So you need to make sure you can guess. All right. Which of the following has authority over the printing of currency? This is another kind of obscure question, as if we could study every part of the bureaucracy and what they do. But I know what some of them are, so I can eliminate them. All right. I know what the Offices of Management and the Budget does. They advise the president on his budget, so I don't think they print currency. The Council of Economic Advisors, they advise the president on economic issues. They don't sound like they print currency, even if you've never heard of them. C, the Department of the Treasury. Actually, your money is called Treasury notes. It is actually a debt of the Treasury. That's the answer. You might think it's the Federal Reserve Board because we call it printing money when they create electronic money and use that to buy bonds and what we call quantitative easing. But it's not actually printing the currency. We call it's printing electronic money. So I would have guessed between these two and put C. The House Appropriation Committee is in charge of spending money, right? And allocating the budgets of every agency to spend. Let's go to 8. A non-litigant. Now this AP test seems to think you know what litigation is. And another AP test after this one asked about litigation on the free response. So litigation is arguing a case in court. All right? That's what a litigating is. All right? So a non-litigant, so somebody who's not arguing the case in court, group or individual that wants to attempt to influence the court in a particular case. So how can you lobby the courts? If you're not involved in the case, but you still want to have your input. If it's maybe a black civil rights case, and you're not actually the defendant or the prosecution, the plaintiff. I guess it's not a criminal case. So the plaintiff, how do you still maybe influence the judges? Is you write a friend of the court brief. I've been calling it an amicus curiae brief, but I'm pretty sure it's amicus curiae is the Latin pronunciation. So that's a friend of the court brief. And let's look at the other choices real quick. A writ of error coram nobis is, I knew what that was literally a few months ago and I've forgotten. So that's obviously not the right answer. Don't put things you've never heard of, right? It's very likely you've at least heard of all the answers. All right? Habeas corpus petition says I have a right to appear before a judge and have my charges explained to me. It means you can't lock me up without charging me. Writ of certiorari is the way the Supreme Court tells everyone they're going to hear a case. And then a writ of mandamus was the subject of Marbury v. Madison. It will probably not be the answer to any of your questions. They just wanted another Latin word to throw on there. Marbury v. Madison had to do with the court's original jurisdiction, which did not include the writ of mandamus. Which of the following best describes civil liberties? So this may be a question about the difference between what we call civil liberties and what we call civil rights. Liberties are about the nature of the rights themselves, whereas civil rights has to do with the historical struggle of certain groups like black people or women or Hispanic people, for example, to gain equal rights. Civil rights is about equality. Liberty is about due process and the rights themselves. So let's see. The freedom to refuse to obey laws that an individual considers to be immoral violation of civil rights. There's actually a term for that called civil disobedience, which some people consider a legitimate way to protest a law. Like Gandhi did this and Martin Luther King did this. But that's not the answer here. Provisions in the Bill of Rights that provide guarantees against arbitrary interference by the government. That sounds maybe like civil liberties. It's maybe an indirect definition of civil liberties. Maybe there's a more direct one as I look through it. But yeah, the Bill of Rights does have civil liberties in it. Protect you against arbitrary interference by the government. Precedents pertaining to criminal procedure that are set up by the Supreme Court and upheld by lower courts. That's kind of what precedent is, but I don't think that's the good definition of civil liberty. Those features of the 14th and 15th Amendment of the Constitution that pertain to the actions of individuals and groups. 14th Amendment does have to do with due process and equal protection, so the 14th is related to both civil liberties and civil rights. We'll see next week. The 15th has to do with you can't prohibit somebody from voting based on their race. So I guess that is a civil liberties issue, but civil liberties is bigger than just that. And E, laws passed by Congress to define the powers and privileges of individuals. Civil liberties are not the result of laws. They're the result of the Constitution, and we would say maybe nature. We have natural rights. So I think B is the best answer. It's a little bit indirect, but it is a description of civil liberties. All right, let's jump over here to this policy question. This is actually kind of an economics question. Do y'all remember the different tax systems? This is a good economics review then. Let's see if I can zoom in just a touch. Okay. This is a tax whereby a citizen pays a higher percentage of their income compared with, a tax where a poor citizen pays a higher percent than a wealthier citizen. Okay, so there's three main types. We have a system, let's say we had maybe poor and middle class and then rich. And let's say we had a system where the poor paid a smaller percent, the middle class paid some larger percent, and the rich paid the largest percent. Well, that's called either graduated or progressive. All right, that's called graduated or progressive. A lot of people that don't like a progressive income tax call it graduated because they don't want to imply progress. All right. If everybody pays the same, it's called flat tax. So that would be, say, 15% across the board. And then the opposite of a progressive income tax is a regressive income tax. It kind of sounds mean, or like you're regressing. And it appears to be kind of hard on the poor, at least, whether it's mean or not. It's kind of a normative issue. But it taxes the poor at a greater percent than it does the rich. And our income tax is progressive, but certain things like sales taxes can be regressive because the poor spend more of their money and you've got to pay sales tax on money you spend, whereas the rich are able to save more of their money and they don't pay sales tax on money you save, so it can be regressive. All right, so I don't know what's the answer here. I'm sorry. That'd be a regressive tax. All right. All right. So let's jump to the next one. 12 says, from Matt v. Ohio, which we just learned in all but one of our classes today. This is the case that incorporated the exclusionary rule for unconstitutionally gathered evidence. But I bet I don't have to know that. I bet if I just read this passage, it will tell me the answer. It says, just as the Fourth Amendment's right to privacy has been declared enforceable against the states through the Due Process Clause of the 14th Amendment, that's what incorporation is. It's where the Due Process Clause of the 14th Amendment applies Bill of Rights protections to the states. Let's see if that's what this says. It is enforceable by the same sanction as it is used against the federal government. So the states have to follow the same due process as the federal government. That sounds like incorporation. Were it otherwise, the assurance against unreasonable searches and seizures would be a form of words valueless in the concept of ordered liberty. So they're saying the Fourth Amendment is an essential, search and seizure liberties are essential enough to apply to the states. And so let's see which one we would put. What two principles are... Ooh, two principles. Okay. All right. The incorporation doctrine. I'm thinking, no doubt about it, it's number one, because that's what the incorporation doctrine is. And I like these questions, because now I can eliminate D and E, and so it's either got, well, that didn't really help me, though, because it's either got to be 1 and 2, 1 and 3, or 1 and 4. The concept of eminent domain, I actually know it's not that, because we're going to learn what eminent domain is on Monday. That's the government's right to seize private property. And in our Constitution, they can do that as long as they use it for some public use, so some sort of government public use. Can they turn it over to a private business? That's kind of a constitutional gray area, controversial area. It has to be for public use, and they have to provide just compensation, meaning they got to pay you some just amount for it. But that's also up for interpretation. This doesn't have anything to do with that. The exclusionary rule, that's the idea that when you search and seize something without a warrant, it's excluded as evidence. And that's sort of what we're talking about up here. All right? If you go back to the passage, they're talking about search and seizure, I think. Yeah, assurance against unreasonable searches and seizures. Okay? And it is talking about how the right to privacy is enforceable against the states in the same way it is against the federal government, and the way we enforce the right to privacy against the federal government is the exclusionary rule. So it might be the exclusionary rule. I like 1 and 3. Let's make sure 4 is not good. Well, the separation doctrine has to do with religion, so it's not 4. So I guess it has to be 1 and 3, so B. By the way, let's say you didn't know number 1, but you knew 3 was the answer. All right, well, then it's either got to be those two. It's either got to be 2 and 3 or 1 and 3, so 4 can't possibly be the answer. So I can eliminate everything with 4. Oh, I can eliminate A, so if you just know that 3 is the answer, you can eliminate all but 2 of the choices. And eminent domain is the most ridiculous answer out there. So I like these questions. You should not be intimidated by these 1, 2, 3, 4 questions. They actually can be easier to fake your way through. The United States Supreme Court, number 16, God, there's a lot of these. The United States Supreme Court has used which of the following to incorporate the Bill of Rights into state law? It's the 14th Amendment. That's what incorporation is, the Due Process Clause of the 14th Amendment. It is not the Necessary and Proper Clause. That's the elastic clause. It says Congress also has powers that they might need to carry out their other powers. 14th Amendment is the answer to B. The Judiciary Act of 1789 was the law that was in question in Marbury v. Madison. As a fact, they would probably not want you to, not care if you know. They want you to know Marbury v. Madison established the idea of judicial review. Alright? They don't want you to know the details of the backstory. The Civil Rights Act of 1964 and the Voting Rights Act of 1965 are issues we're going to learn next week. That basically, guess which one has to do with voting? They both involve civil rights, especially for racial minorities. They're both part of the Black Civil Rights Movement. Guess which one has to do with just voting? The Voting Rights Act of 1965. Sometimes they call it, though, the Civil Rights Act of 1965. So you kind of need to remember the 65 one was voting only. The 64 one was much more broad and sweeping. It involved voting rights and also access to public accommodations, meaning like restaurants, water fountain, bathrooms, hotels, things like that. And it also involved employment. So it's illegal to discriminate in employment based on race, ethnicity, and also they also mentioned sex when it comes to the employment part of that. All right, so there you go. We'll learn about those next week in a lot more detail. All right, which of the following did the Supreme Court establish in Marbury v. Madison? You need to know that in Marbury v. Madison, the Supreme Court established judicial review. You need to know that judicial review is established in, and then you go find Marbury v. Madison in the list. You need to be able to define judicial review. It's the main check the courts have on the legislative branch, the executive branch, the president, the bureaucracy as parts of the executive branch. So the check they have on the state governments, on local governments, on school districts. It is the power of any national court to declare any government policy unconstitutional and therefore void. You need to know that definition by heart. They will put it on their free response. Define judicial review. All right? So let's see. The Supreme Court can declare legislation invalid. The legislation violates the Constitution. That's judicial review. Kind of a limited definition, just talking about laws, legislation, but it's true. Each state has a right to set up and run its own court system. No, that's the idea. We have a dual court system with national courts and state courts. C is all the powers that are not explicitly given by the Constitution to Congress belong to the states. That is true. What amendment says that specifically? We call these the reserved powers, the state powers. They're not mentioned as one of Congress's powers, so we just assume they belong to the states. That's the 10th Amendment. We'll learn about the 9th on Monday, but the 10th Amendment says any powers not given to the Congress, given to the national government, belong to the states. Any president who commits treason, bribery, or other high crimes and misdemeanors can be impeached. Okay, that's not it. And the Constitution can only be amended by a 2/3 vote of the members of the House of Representatives. That is patently wrong. Amending the Constitution is a two-step process. And just a quick reminder, the fractions go up. Amending the Constitution should be harder than passing a simple law, which requires a simple majority. So you've got to go up a fraction. It's got to be 2/3, so you need 2/3 of both chambers of Congress to even propose an amendment to the Constitution. And then actually ratifying it, making it part of the Constitution, is even harder. You've got to go up a fraction, and now it's no longer Congress, it's up to the states. We need 3/4 of the states. And if you kind of remember that you got to go up fractions, and it is as an example of federalism, so the states are going to be involved, it helps me remember 2/3 of both chambers of Congress to propose, 3/4 of the states to ratify. And that's pretty much the details you need to know. And you also need to know that's an example of federalism that they put in the Constitution. God, there's a ton of these. All right, the number of justices on the United States Supreme Court. Remember, the Constitution says two things about our court system. There's going to be a Supreme Court, and it establishes its original jurisdiction. All the other details are up to Congress. It's a good idea to go back and look at that graphic I gave you of our judicial system. Here it is. And these two parts in blue that I wrote set by Constitution on are the only parts set by the Constitution. All the other parts that say Congress by them are established by Congress. So all the details of the inferior courts, or we call them the lower courts, the 94 district courts, their jurisdiction, which is only original jurisdiction. The 11 circuit courts plus one in Washington, D.C., and their jurisdiction and their structure. By the way, their jurisdiction is only appeals or appellate jurisdiction from the lower levels. And then the original jurisdiction is set by the Constitution for the Supreme Court, but the appellate jurisdiction is set by Congress, and so is the number of justices. So the answer here ought to be Congress. I kind of hope it is. B, Congress. What 29, the President's role as chief diplomat. Is that a... Oh, we already did that one. All right, let's bump ahead to the Jim Crow laws. Again, this is a civil rights issue, but these were laws in the South designed to deny black people certain civil rights, especially the right to vote. Now, in theory, the 15th Amendment said you can't deny somebody the right to vote. And the 15th Amendment was signed right after the Civil War. Signed, I guess, ratified by the states, I'm sorry. Right after the Civil War. But the South still found ways to do this. We're going to see in class that people in the South still intimidated black people into not voting. They had what was called an all-white primary. Because in the South, Democrats won most of the elections. Not today they don't, but back then they did. The Democrats won almost all the elections in the South. So the general election between the Republican and the Democrat was a foregone conclusion. It didn't matter who voted in that, because the Democrat was going to win. So the real election was the primary. And so they said, oh yeah, we can't keep black people from voting in the general election, but that one doesn't matter. they made primaries all white. Only white people could vote. So that was a way to keep black people's vote from counting. They gave them literacy tests, which were supposed to be to say, oh, if you can't read, you can't vote. But the literacy tests were very hard. It was more than just can you read. And a lot of your people in the black people in the South right after the Civil War weren't educated enough to pass those tests, nor were the white people. But the white people had an exception. They also made them pay poll taxes, which basically said you got to pay a tax to vote. And many of the black people in the South, after they were free from slavery, couldn't afford to pay a poll tax. Neither could some of the white people. But the white people had exceptions called a grandfather clause. They said if your grandfather could vote, you're exempt from all these requirements. So, anyway, all those were part of Jim Crow. And what sort of swooped in and outlawed all those restrictions on black civil rights? I don't think the incorporation of the Bill of Rights did. The 1963 March on Washington was a civil rights action by the black civil rights movement. They certainly didn't do it. Oh yeah, well they tried to outlaw it, but they don't get to make laws at a March on Washington. This act of Congress sounds like a law. And that's what the Civil Rights Act did. It was voting rights plus other stuff. Jim Crow also said, you know, you can have separate bathrooms for black people and separate schools and things like that. The Supreme Court decision in Brown v. Board of Education is going to be where they take a previous decision that said separate can be equal, that previous decision, Plessy v. Ferguson, from late 19th century. And they said, no, that separate is inherently unequal. Linda Brown and all others similarly situated, because it was a class action suit, she can go to the all-white school, and actually you have to integrate your schools. They said to the South, you got to integrate your schools with all deliberate speech. Right? The Dred Scott case was sort of the opposite of this. It was a victory for states' rights and not for the slaves. It's kind of said slaves are property no matter where they go, even if the federal government says they're not. All right? It was a ruling. It was a rare ruling in favor of state power as opposed to national power, and it was inherently racist. So you need to look up that Dred Scott decision, although we will talk about it next week. In Gideon v. Wainwright, this is where Clarence Earl Gideon writes in pencil his informa pauperis petition to the Supreme Court and says, it seems that the Sixth Amendment seems to say I have the right to counsel, the right to an attorney, the right to a lawyer, but I couldn't afford it. I don't have that right because I can't afford it? What gives? And the Supreme Court said, you're right. And so, let's see, it's not a exclusionary rule. It's not about the exclusionary rule, it's about the right to a lawyer. Exclusionary rule is about unconstitutionally gathered evidence, whether it was from torture, so a violation of the Fifth Amendment right to remain silent, or it was from unwarranted search and seizures, so a search without a warrant. Eminent domain, remember, is seizing private property. The Sixth Amendment right to counsel provision applies to those accused of major crimes under state laws. So yeah, another thing it did, besides saying you have to provide them with a lawyer if they can't afford one, was it incorporated the right to counsel to the states. At least that's the answer. Yeah, and the Eighth Amendment's about cruel and unusual punishment, and that wasn't employed. This is one of those cases you need to know by heart, and I'll give you a list of the ones you need to know to memorize the names of them before the test starts. All right. In fact, I got the list right over here. I just haven't Xeroxed it in here yet. The free rider problem, this is a kind of an economics and government problem. This is a situation, and I don't think it even belongs on this test, but here it is. The free rider problem is when, if there's some sort of public benefit that we will all benefit from out there, but it requires some of us to pay a cost to go get it. The free rider problem is if we can all have it, whether we pay a cost or not. The incentive is let somebody else pay the cost. And I'll just free ride on their efforts and I'll get the public benefit. Okay? So the free rider problem is where there's some public benefit that everybody can enjoy and we can't keep them from enjoying it. And even those that don't pay the cost can enjoy it. All right? And it kind of is a reason that public goods don't get produced by the free market. Because if, for example, a few of us got together and paid the cost of building a lighthouse, everybody who sails in the harbor can see the lighthouse. And they would have all, you know, the incentive would be for them to not help us pay for the lighthouse because they could see it whether they paid for it or not. They'd be free riding on it. So, let's see. Interest groups, it also applies to interest groups because it's hard to get people together for collective action, to work together, because if an interest group goes to Congress and achieves some public benefit for everybody, I get that public benefit whether I help pay dues to that interest group or not, or whether I actually went to Washington myself or not. So it also is an interest group problem. Let's see if we can find the answer. Interest groups seek public funding to advance their special interests. Well, maybe. People benefit from an interest group's efforts without making any contribution. They free ride. Boom. So that would be B. All right, let me look at these other ones. What is this called where congressional candidates win elections because they belong to the party of a popular president? They sort of ride into office on his momentous coattails, and that's a rare phenomenon in modern politics. Because people don't run as part of a party, they run as an individual, so unless people click the straight ticket vote. So they vote for a popular president, and they might switch parties to vote for a congressman. All right, according to the clear and present danger test, speech can be restricted. This is a fighting words, public safety, national security issue. All right, it incites violent action. That sounds like a pretty good either national security or public safety reason to me. That's not the answer. C, no. Even offensive to religious organizations, no. The writer speaker is not a citizen of the United States. So remember, clear and present danger test means speech can be restricted, but you've got to show that there's a clear and present danger to public safety or national security. What's the next one? Are we done? Holy cow, we're really done? Alright, I'll see you guys Monday. We'll go over the full free response section. Wow, alright. Keep it real.